Hi, I'm Al Charbonneau, Executive Director of the Rhode Island Business Group on Health. Thank you for joining us today in this important employer event to discuss the implications of the Consolidated Appropriations Act of 2021, otherwise known as the CAA 2021. Today, we'll focus on two of the most important provisions of the Act: transparency requirements and surprise billing. I'd like to begin by thanking our sponsors who support RIBGH's work, including this webinar today. I know I speak on behalf of the RIBGH board and our members when I say we are truly grateful to our platinum sponsor, Mercer, our gold sponsors, Blue Cross and Blue Shield of Rhode Island, United Healthcare, Neighborhood Health Plan, Tufts Health Plan, whose parent company is Point32 Health, and Aetna. Our silver sponsors, USI Insurance Services, Merck, Novo Nordisk, Delta Dental. We are also thankful for our RIBGH members, a growing group of 90+ companies representing over 80,000 employees. Before introducing today's expert speaker, I would like to note two logistical items. The first is, in the interest of time, we only do brief introductions. Speaker bios are located at the RIBGH website. And the second is that put questions that you have in the Q&A tab, I guess you would call it. We'll be exploring those questions at the end of the presentation. It is now my pleasure to introduce the speaker for today. Patricia Trish Farrell is a senior attorney in the Princeton office, the Princeton, New Jersey office of Mercer Health and Benefits. Trish advises employers on income taxes, HIPAA, ERISA, ADA, Medicare, FMLA, COBRA, and retiree medical issues associated with health and welfare benefit design, reporting, plan governance, and administration. She is a speaker on the national scene and at seminars sponsored by Mercer and other employer-focused organizations. Please join me virtually in welcoming Trish Farrell. Trish?
Hi. Hi, everyone. Thanks so much, Al. Lots to cover today. So let's get going. There's been a tremendous focus on transparency on healthcare prices, stemming not just from the Consolidated Appropriations Act that Al mentioned, but also from the Affordable Care Act. Okay, I'm going to refer to the Consolidated Appropriations Act as the CAA. Much too long otherwise. We'll go over these new developments and then how they impact your health plan and steps you should consider taking to come into compliance, including ways to work with your vendor partners or carriers and potentially other third parties if you see fit. Both sets of rules, and I probably should move along here. Both sets of rules aim to address what are concerns about wide price variations and aim to reduce healthcare waste and have individuals make more informed decisions about their healthcare. Sounds great, right? But the devil is always in the details, as they say. We're going to start with this slide that lists all of these new requirements and when they take effect. And then we're going to hone in on a few specific ones, like the machine readable files that are coming due soon, and surprise billing, which will have a pretty big impact on group health plans in years to come. And some of these requirements, as you see, have already kind of taken effect already. In an effort to make things more transparent, contracts had to remove any gag clauses that might have been part of those contracts, and that already took effect as of the end of 2020. Another requirement that we'll speak to in a bit more detail soon makes it a fiduciary obligation for group health plan sponsors to obtain from their brokers and consultants that service their plan information on how much those brokers and consultants get paid. You'll see for 2022, there's a lot of there's a lot of line items here. And I'm sure that many of I'm sure that many of you have already done some things already for compliance with these requirements, such as making sure, and like perhaps likely even in advance of 2022, like making sure that plan participants have ID cards. A lot of plans had the ID cards for years, but now this is a federal requirement, and some detail has to be on those ID cards. Okay, many plans had continuity of care provisions in them already, where if someone is undergoing a certain treatment by a provider, and that provider leaves the network, that for some period of time that care with that provider would be considered, treated as in network. Well, this is now a federal requirement. Okay. Provider directories have to be kept up to date, have to be updated every 90 days. And if someone relies on an out-of-date provider directory, the plan has to treat that care as in network. Kind of hard to figure that one out, but that is the rule. And then there's a lot of, there's a lot to discuss about surprise billing. We're gonna talk about that in more detail in a few minutes. The rules are pretty extensive and maybe one of the most labor intensive requirements that carriers are gonna have to deal with now. I'm gonna spend a few minutes on the requirement that plans post for the whole world to see information on what plans pay with respect to in-network services to in-network providers, and also to what has been paid for out-of-network providers. And then by the end of this year, lots of information will need to be reported to the government regarding drug prices and other healthcare costs as well. There's a slide on that I'll get to in a few minutes. And then by next year, plans will have to provide an internet-based tool that would help plan participants figure out how much a particular procedure might actually cost. So, and it has to be very smart. So, so if I wanted to figure out how much like a particular procedure, like a knee operation would cost, I should be able to go onto this internet-based tool, plug in some information about myself, what plan I'm in, what procedure I want, and then that tool should be able to spit out to me based on in real time, how much that procedure would cost me, the cost sharing that I would actually experience based on the deductible that I've already met and any out-of-pocket thresholds that I've accumulated towards. For the first year, for 2023, 500 specific items and services have to be loaded into that tool, and then by 2024, all items and services that the plan covers must be included in that tool. So it's so as you can see, with all of these, pretty much all of these requirements, employers will have to rely heavily on their vendors for support. But self-funded plans, like carriers of fully insured plans have to do all this stuff, okay? But with the self-funded plan, you're going to have to rely on your carrier for support in all of these areas. But ultimately, it's up to you to make sure this is getting done. Okay, let's get into a little more detail about the machine readable files. So this is from the ACA rules, and the ACA rules required transparency with respect to the ACA transparency rules require transparency with respect to hospital costs and for group health plans. We're not going to get into detail about, we're not going to go in any detail about the hospital transparency rules, but I just wanted to mention that the hospitals are affected by this too, just to illustrate how wide, wide-ranging this transparency effort has been. With respect to group health plans, plans have to provide machine readable files in two formats. Okay, one provides the the rates that have been negotiated with in-network providers, and the other has details what has historically been allowed for out-of-network provider payments. Okay. There was a third requirement, and that dealt with prescription drug information. But these rules were issued in the fall of 2020, and soon after we got the CAA, and the CAA has extensive prescription drug reporting. So the regulators decided at the end of last summer to postpone indefinitely the drug file, the machine readable drug file, and it might actually go away. We'll see. But for now, we have these two files that must be posted, and they have to be. They apply to non-grandfathered plans. Okay, major medical plans. They don't apply to health FSAs or dental or vision, retiree-only plans, but major medical type plans. And they have to be made available on a public website. Okay, and for the whole world to see. I say that often, for the whole world to see, because the idea here is they're not participant-focused disclosures, unlike so many other disclosures plans have to make. These are not, that's not the intent here. The intent here is to let other stakeholders in the healthcare industry and the government find out information about different and about these different on how different plans pay providers. And it's the goal and the aspiration is that if making all this information available for the whole world to see, that the healthcare industry will become more competitive with the goal and aspiration that that prices will go down. Time will tell if that will happen, but that is one of the objectives of having these machine readable files available for the whole world to see. They have to be updated monthly, and we're not sure if what records have to be kept of past files, but they do have to be updated monthly. And then that I've talked to a lot of employers about where to post this information. As I said, they have to be available public, on a public website. And the rules talk about a public website of the plan. Now, plans don't, self-funded plans, up until this requirement, plans haven't had public websites for an employer wouldn't have a public website for their plan, so to speak. But this requirement seems to assume that plans do. Okay, these types of files are not files that an employer will want to either develop or host. Okay, so how do you actually make them available? One of the what an employer can do, the employer with a self-funded plan can do, is find some real estate, someplace on its own company website to make mention of of these files, and then link out to where they exist at the carrier level. Most of all of the carriers that we've been speaking to will allow for that type of process, and they understand that employers don't want to host these files. They're going to be, all the major carriers that we've spoken to are going to host these files and provide links to employers to put on their website to link out to those to the carrier websites. There can't be any type of username or password requirements, and they have to be free of charge, and they have to be discoverable. Okay, so someone should be able to do a Google search and find out, okay, what are the health plan costs for the XYZ medical plan, and that should take that searcher to a website or some link to some site that says something about the XYZ health plan some mention of those machine readable files that then links out to the carrier website where they exist at the carrier level. Okay. Employers don't have to set up their own websites just for these files, just to mention these files. A lot of employers that I've talked to, they don't really want this on their homepage. Okay, they're trying to figure out like where to make mention of these files. Some clients I've talked to are putting them on a career page. Well, actually, and some clients I've talked to actually have a public have a website for benefits that anyone can go to. It's just that if you want more information about the benefits, you have to put in a username and password. But they have a landing page for their benefit website. So if you have something like that, that might be the appropriate place for this. Another place I'm hearing that some clients are putting mention of these files is on like an About Us tab on their homepage. So there's no one specific place where mention of these files has to be. It just has to be a publicly available, no credentials required and free of charge and discoverable. Okay. On to the next page. I'm only showing this page because, I get this question once in a while. What do you mean by machine readable? It's not something that like anyone can look at and make any like heads or tails out of. Okay, it's intent. This is lots of data. Okay, that's in these files that would be digestible by a computer. It's not, like I said before, it's not a typical disclosure of a health plan to plan participants. So that ERISA rule about, making the disclosure, that's what is it for the average plan participant, that doesn't apply here. Okay, this is for all those other parties, and so the machines, like a computer, can digest this. So again, this is not something that an employer would want to develop, okay, or likely host as well. Okay. On to the next page. Okay, the next topic I'm going to talk about is dealing with prescription drugs. This is part of the CAA. And whether the plan's insured or self-funded, grandfathered or not, okay, your plans have to report massive amounts of information to the government, all in an effort for the government to get a better idea on health costs, healthcare costs. And while the reporting is called prescription drug reporting, it's really much more than that. Okay, it's reporting on hospitals, what healthcare costs the plan incurs with respect to hospital care, outpatient visits, whether the care is for a primary or specialty provider. And the idea is to compare, we're told, the idea is to compare prescription drug costs relative to overall healthcare spend. Okay, CMS, the Center for Medicare and Medicaid Services, has created a portal for submission of all this data. Some specific plan information needs to be reported, like the plan year, the states where the plan is offered and the number of plan participants. But the information that's really of interest to the government will be reported in aggregate form. Okay, that is total healthcare spend on an outpatient basis, total healthcare spend on hospital care, and details by primary and specialty provider. And of course, lots of details on prescription drugs. And also they're looking for information on wellness incentives, and also wellness and what plans pay for education on wellness, believe it or not. Specific information on the costliest drugs is required, plus a good deal of information on rebates. Plan sponsors can submit this on their own, but the way the reporting has been set up by CMS, they really want aggregated, and they want the TPAs and the carriers to report, and the PBMs to report this information. They don't want individual plan sponsors to submit this information. So you're going to need to work with your, if you have a PBM, you're going to need to work with the PBM to get this information, get the information that they deal with reported, and you're going to need to deal with the medical carrier to make sure that the information that they deal with gets reported. While the TPA and the PBM can report on behalf of a plan sponsor, if the plan's self-funded, the employer has to make sure it gets done. Okay, so you want to make sure you have these, you're talking to these the vendors well in advance, okay, of when this reporting is due. The reporting was supposed to be due, the first report was supposed to be due at the end of 2021, but it was pushed back until the end of 2022. And by the end of 2022, CMS expects that information for calendar year 2020 and calendar year 2021 will be reported by the end of 2022. After that, reporting will happen every June for the prior calendar year, regardless of plan year. They want this information on a calendar year basis, so they have a more uniform picture of the spend. Okay, so even though December might feel like a little far off, you know, we're not, you know, the weather's just starting to get warm here now. I'm in Princeton. In December might feel like a long way off. It will be here before you know it. And so you really want to make sure your vendors are on top of this for you. Okay. And then if we go to the next page, okay. Okay, this broker disclosure requirements. Okay, this is an effort for even more transparency regarding plan costs. And so the CAA requires ERISA-covered health plans and those servicing those health plans to comply with new rules regarding disclosures on like how much those how much brokers and consultants are paid. Under ERISA, it's a fiduciary violation for plans to pay more than a reasonable amount to anyone servicing the plan. There's long been a requirement for retirement plans to obtain disclosures from their service providers, from those retirement plan service providers, about the fees paid to them. The CAA adds a similar requirement for group health plans. So beginning with contracts that are entered into on or after December 27th of 21, plans must obtain information about direct and indirect compensation expected to be paid by brokers and consultants, where that compensation is expected to be at least $1,000. Okay. The consulting service, like broker services are pretty clear. Consulting services are not so clear, but they're like any service provider that provides services related to like medical management, disease management, and wellness should be included. The Department of Labor, which is the enforcement agency for ERISA, they haven't issued any regulations on this requirement, but they did issue a field bulletin. And in that bulletin, the Department of Labor says that the disclosure requirement applies not only to medical plans, but other ERISA plans like dental and vision, anything that kind of meets, anything that think about what plans you offer COBRA for, okay? Those are the types of plans that they want disclosures regarding. And in this field bulletin, the Department of Labor said that plan sponsors and service providers can look to the regulations that currently exist for retirement plans for some guidance in this area. There's no specific reporting yet out to the government on these disclosures that plans have to obtain, but I can envision that the Form 5500 might be modified at some point in time to try to for the government to get this, for the government to get this information from you. Okay. The next topic is surprise billing. Okay, let me get to that. Okay. For years, Congress was debating on how to handle situations where patients are met with a surprise bill or an unexpected bill. This happens, and I'm sure it's happened to many of you on this phone call, where you go into an in-network facility thinking that all your care is going to be in network. You're in the, you went to an in-network facility, right? But sometime during that visit, you're seen by like, you get an x-ray taken, you get lab, you get lab work done. There might be an anesthesiologist involved. And one or more of those providers might not be in network. They're providing services in a network facility, but they might not be part of the network. And lo and behold, a bill comes in the mail for, those out of network service, and it's a surprise. Okay. Because of this, many states enacted laws to kind of deal with this situation, including Rhode Island. Okay. But those rules would apply only to insured plans. Up until recently, up until the CAA, there was no federal law on surprise billing. But now we have the CAA that addresses this problem. The No Surprises Act deals with services in 3 settings. The one I already mentioned, where someone goes to an in-network facility and is seen by an out-of-network provider, but it also applies when someone goes for emergency care. Okay. And also applies in a situation where someone receives air ambulances services. I don't really know that much about air ambulances services, other than they've been very expensive. So I'm not going to really focus too much on that. But the basic structure of all this is that there's not going to be any balanced billing. Okay. And so someone goes to this facility or goes to the emergency room, all of their care is going to be considered in network. Okay. And there can't be any balanced billing. Any cost sharing that applies, okay, will accrue against the individuals, to that plan participants in network deductible and in network out-of-pocket maximum. And then the plan and the provider basically have to duke it out. Okay, so and we'll get to that in a minute, but the point is the plan participants out of the picture at that point in time. Okay. With this law, the Congress also took the opportunity to provide other protections as well, like the definition of emergency services. So it's a prudent layperson definition. So if I go to the emergency room with a reasonable belief that I'm experiencing an emergency, my care has to be treated as an emergency, and it has to be treated as in network. The plan can't later determine after the fact that, oh, well, these codes apply to this care, so we're not going to treat that as an emergency. Plans can't do that anymore. And there's other, so we have the prudent layperson standard that applies to here, and services through post-stabilization in the emergency room need to be treated as out of network as well. I'm sorry, need to be treated as in network as well, sorry. And even if the docs think that the person can be moved, if it would be a hardship to that person to move them, then the individual can stay where they're at and get in-network treatment of their care. Okay. So let's go on to the next slide. How do out-of-network providers get paid? Okay, so, oh, I'm sorry, this is non-emergency service. I think we talked about this already. The same, so you're in one of these, you're in the network, in the network facility, you get seen by an anesthesiologist, a lab, worker, lab tests, all that stuff has to be treated as in network. And how do people find out about this? Okay. Plans have to post, again, on a public website, okay, notices about their protections under this law, okay? And then every EOB that deals with a service that's covered under the No Surprises Act must include information about these protections. The government issued a model notice, okay? This notice was supposed to be provided to, posted by the first plan year in 2022. I'm still getting lots of questions about it, and even though it's into April, even for plans that were calendar year plans. And I like asking me about where to post this. Like, unlike the machine readable files, this notice really is, excuse me, this notice is really, excuse me, this notice really is about, a participant focused notice, okay? So I don't really see the public policy interest in putting this on a public website of the employer. I think it's reasonable to include this in the like your benefits website that's directed at plan participants. I don't think the agencies will take, unless they come out with more guidance on this, I don't think the agencies would take any enforcement action against an employer that doesn't post something like this on a public website of their plan. I've gotten questions about posting this, relying on the carrier to post this notice, and not posting anything about this on the employer website. And I think that would work, okay? It's just that, if you're relying on the carrier's notice, it's going to include information about state privacy protections if that carrier is subject to those state privacy protections. And self-funded plans, for the most part, aren't, unless the self-funded plan has opted in, and in part of a state that has an opt-in provision in it, those state privacy protections wouldn't even apply. So I'm a little cautious about relying solely on the carrier's notice for this requirement. Okay. But I don't think it's an issue for plans to limit the posting of this notice to plan participants. Okay. And then, so I mentioned before, no balance billing, the plan participants out of the whole process. Okay, so the plan and the provider have to duke it out as to how much the provider gets paid. I'm sorry, how much the provider gets paid. So there's a process for that, very detailed process, and the plan has to send a payment to the provider. It's called the initial payment, but it's not like a down payment or anything like that. It's what it's supposed to reflect what the plan thinks that is owed to that provider. And then there's a negotiation period where the provider said, no, I think I should be paid more, blah, blah, blah. And then if they don't come to agreement, either party could initiate independent dispute resolution. And that's almost always going to be initiated by the provider, because the plan's the one sending out the payment. So if the provider has the problem with it, the provider is going to initiate the independent dispute resolution. So there's a whole process in place for how this is done. Okay. And then, and if they don't come to agreement, they would go to IDR. There was a lot of rules about how the IDR process would work. And one of the arbitrator, okay, uses like the baseball type baseball style arbitration. And that means, okay, each party submits what they think should be paid. Okay. And the arbitrator picks one of those amounts. And the rules that came out by the Department of Labor said that, okay, the one that was closest to this qualified payment amount set forth in the regulations would be the one the arbitrator had to pick. And that would favor the plan. Okay. Many providers sued over this, and they thought that that's not what the law said. The law said a number of factors had to be taken into account in the IDR process, and the rules were like placing the thumb on the scale of what the plan came up with. And so, this lawsuit, provider sued, and the court agreed with them. The court agreed and said that that's not what the law says. And so back to square one now on how that amount to be paid by the plan to the provider would work. The Department of Labor vacated those earlier rules. Well, it's supposed to come out with new rules by May of this year, okay? But regardless of what rules they come up with, there's likely going to be a party that's not happy, and they're probably going to have more lawsuits about this. And, so this is far from over, okay? And given the uncertainty of the IDR process and the costs associated with it, okay, there are costs. So if an IDR is initiated, each party pays a certain amount, like $50, I believe, for 2022. And then whoever loses an arbitration pays the arbitrator's fee. And there's some set amounts to that, but there's fees associated with all this. So given the uncertainty about it, we still don't know how this is supposed to exactly happen. Plan and providers, might be somewhat motivated to try to avoid the process, use that negotiation period to figure out, the best way to handle all this stuff. And then the next slide. Okay, on this next slide, I just have like a checklist for all these rules that we just went through. I'm not going to repeat them, okay? But instead, I wanted to leave some time for any questions that you might have. Al, do we have any questions?
We do. Can you hear me, Trish? Can you hear me?
I can hear you, Al.
Oh, okay, excellent. I'm sorry. So actually, but one question I want to ask first before we do some of the attendee questions. I've heard from people in the retirement business that back around 2012 or 2013, the federal government passed fiduciary responsibilities that actually dramatically changed the industry. Do you think that these CAA fiduciary responsibilities will have the same impact?
Well, it was long ago and far away when I did pension work. So I'm not familiar with those retirement rules to even I'm probably not the best person to answer that specific question, but that slide I did go over, okay, did about the broker and the compensation to brokers and consultants. I think that's what you're getting at. Okay, retirement plans have to disclose, have to obtain disclosures from their service providers. Yes, this is because sometimes you don't always know how much the broker or and the the consultant are getting paid, because there's a lot of hidden stuff that might not be as transparent to the plan sponsor on as to what that broker or consultant is getting paid for by vendors. So all of this now needs to be disclosed.
Okay, so we have a question also. Does the CAA 2021 apply to all plans, fully insured and self-insured?
Yes, all those provisions I went over apply to fully insured and self-funded plans. For the most part, if a plan is fully insured, the obligation for the transparency requirements, that all those things I just went over apply to the carrier. Okay. The self-funded plans are responsible for compliance, but will rely heavily on their, the TPA to make sure that these tests are getting done.
But it strikes me, one other question with respect to, and I guess this is just a matter of the degree of difficulty, but there've been a lot of smaller firms, I think some people feel are too small to be self-insured, but have, because of costs, have wandered into the self-insured field. This is going to be, and by the way, without maybe very sophisticated benefit departments, it strikes me that this is going to be a major problem for the smaller firms who are self-insured, but don't have a sophisticated benefit package. And I guess I'm wondering, when the enforcement part of this comes, what do you think the enforcement deadlines, and if they fail to meet those deadlines, do you see that as a problem?
Though, yeah, but Al, I do think though that because if you're a self-funded employer, if you're an employer with a self-funded plan and you're using a carrier as your TPA, that's also, has a book of business that's insured. That TPA, that carrier, is already subject to all these requirements, okay? So it's not going to be as much of a heavy lift for them to do all these things we just talked about for that plan sponsor of this, that sponsor of the self-funded plan. So I don't see many of these obligations falling to benefit staff within the employer. You might need to, I highlighted some of the things you might need to do, like find that spot on your, find a spot on your website where you might want to make mention, where you'd make mention of the machine readable files to link out to the carrier website. But there's not, and also with another thing that you want to do is with respect to surprise billing, you're gonna make sure that the individuals know about their protections, not only with that notice, but also because it impacts in-network cost sharing. Okay, SPDs will likely have to be updated. Okay, due to the No Surprises Act. So those are some tasks that an employer will likely have to take on, but most of these other ones that I went over were going to be handled at the carrier level. Okay? Even for an employer with a self-funded plan. I think other ACA requirements that are much more onerous for employers, like 1095-C reporting is still out there, which is really labor intensive for a lot of our clients. But I think employers need to know about all these rules, but are not going to be doing that labor intensive work to come into compliance.
You think that will place I think employers will naturally look to their brokers, will they not, for this kind of help, or will they look directly to the insurer?
I think it's a combination. Like we're at Mercer, we're helping, we're discussing all these requirements with our clients, vendors, to make sure that the work's getting done.
With respect to we have a question about the details on the Texas lawsuit, and I thought I'd interject that Rhode Island Business Group on Health had taken a position. About 3 or so years ago, there were several bills that came through the State House that were very expensive solutions to surprise billing. They protected the consumers, but they brought in out-of-network prices into network, which we felt, and a lot of people felt, would really impact premiums. And so we opposed those bills. But now we see that that the Texas lawsuit is generating a lot of support. We signed on to a letter with, I think, like 70 organizations from across the country. odd fellows for sure, labor unions and Families USA and businesses and some very big businesses, Boeing and Caterpillar, were all involved in this kind of activity. I just wonder, do you think this Texas activity has legs legally? Do you think that, or will it be something that will eventually blow over? Because it's about price, is it not?
Okay, so this is in relation to the whether the arbitrator can when determined, like in the IDR process, okay, whether the arbitrator could must treat that, or that whether the qualified payment amount, okay, creates a rebuttable presumption that for the amount to be paid by the plan to the provider. Okay, so that's what I talked about before, where the rule said that the QPA is that the arbitrator must choose the amount that's closest to the qualified payment amount, the QPA, and the provider sued, okay, because they said it puts, it creates, and the contention by the providers was that the law doesn't say, the law says number of factors have to be taken into account by the independent dispute in the independent dispute resolution process, but the regulators said that what should get most weight is the QPA, and that's why the provider sued, because it favors the plan, not the provider. So that Texas lawsuit that you mentioned, that's the lawsuit that said, that agreed, that's where the court agreed with the providers, okay? And as a result, the Department of Labor rescinded or, revoked, rescinded that rule and is coming up with new rules. But in the meantime, that Texas decision was at the district court level. So it can get, it's being appealed. I think it's being appealed. And I think that's the Rhode Island Business Group on Health and many other employers signed on to was, this decision by this court in Texas that, found that the QPA should not be the favored amount, should be like, that should be appealed, that should be thrown out. So, or, reversed. And I think that's what you're referring to, Al.
Yes,
Yeah.
absolutely.
Yeah. So, we'll see what happens. It might make its way up. It might make its way all the way up to the Supreme Court. That's why I said, there's a lot of uncertainty in this, and then this is far from over. How this is going to play out.
There's actually one good thing about Rhode Island, well, many good things about Rhode Island, but one good thing about Rhode Island physicians is that they are, I think now our participation in network is upwards of 92-93%.
Well, yeah, and that's a really good point, because one of the stated objectives with the surprise billing regulations was to encourage providers to join networks.
Yes.
Okay.
So we have another question. Does the pharmacy benefit reporting provision mean that self-insured employers who carve out RX will need to submit both RX and medical?
Yes. And you're probably, and we have a lot of client, we work with a lot of employers that have that type of business line. So most likely what's going to happen is you're going to work with your PBM to submit a file on the prescription drug costs, and work with your medical carrier to submit information on the other costs, the other costs that are that need to be reported. And there's lots of detail that CMS has created for how these files need to be submitted. So there's, and I said before, like, it's not, the filing's not due until the end of December, but you need to start working soon to make sure that this is going to be taken care of.
One of our attendees wants to know, have any of your clients come up with any unique places where to put all this publicly available data, the machine readable stuff and other stuff contained in the No Surprises Act?
Yeah, like the machine. Okay, so I mentioned that one of the tasks is to find out, find a spot, on a website, on that's publicly available. I don't think a lot of employers want to put this stuff on their homepage. The first thing they say when someone goes to their site. So some of our clients are putting it on their career site. Okay. I've heard recently that some are putting it on their About Us tab, like somewhere buried in there, but it has to be searchable. So if you, wherever it goes, it needs to be, it needs to be discoverable, with like a Google search or something. So wherever place you find it. Okay. And I also mentioned that for some of our clients, they might have a publicly available website just for like some minimal information on their benefits. Okay, and if an employer has that type of landing page, then that to me that's the most suitable spot if that exists. But I'm not suggesting that needs to be created. Okay.
It feels like we're making a complicated system even more complicated.
Oh yeah, but I will say that this is a lot of stuff to digest. It really is, and the carriers are really busy dealing with all of these changes. But I really expect that within a couple of years, it's going to be like baked into everything we do, and it's not going to be it's a big learning curve, a lot to be done, a lot to get done early on, but I think it's one of those things that it's going to not be that difficult as time goes on. I remember when the ACA came out, I kind of feel like this is like the ACA when it first came out. There was so much to learn, and so it was so chaotic, and all the regulators coming out every other day with new stuff, and it was just so hard to keep up to date with. But I remember saying at the time, we're going to figure all this stuff out. We're going to figure it all out, but we're still going to have those problems with those complicated COBRA questions. And I have been so right on that. Almost every day I'm dealing with a complicated COBRA question, but the ACA stuff is kind of like, oh, okay, I kind of figured that out. So
it takes you 10 years to digest that. We have another question. Can't we simply direct employees to the carrier site for both the surprise billing notice and the machine readable files?
Yes, but how are you going to direct them? Like, you have to direct the public to, like, so that's the thing, is like, this is not just for plan participants. The machine readable files are don't have anything to do with plan participants. They're not, it's not a participant facing disclosure. It's for the whole world to see. So like, Cigna can see what UHC is paying providers. UHC can see what Aetna is paying providers. Tufts can see what Blue Cross Blue Shield of Rhode Island is paying providers. It's for all of this information to be out there for all these different, industry stakeholders to get their hands on.
So there's a further follow-up that I'm not certain I understand, but the question is on our internal website. This is a question asked by the attendee who said, can't we simply direct employees to the carrier for both the surprise billing notice and the machine readable files? And then this individual says, on our internal website. I'm assuming that she's asking, is this a requirement to be on their internal website?
The requirement for the information about the machine readable files has to be on a public website. So if you're linking to the carrier, that link to the carrier must exist on a public website. I'm not so that one I think is very clear. Okay, and the rationale behind that is very clear to me. I'm not that worried, as I mentioned before, when I talked about the No Surprises Act. I'm not that worried about posting on a publicly available website the No Surprises Act notice. And the reason for that is that is a participant-facing disclosure. You want to tell you're required to tell plan participants that they have protections from these surprise bills if they get services, if they get services like emergency care services, or if they go into an in-network facility. That is, that is participant focused. Okay, so if an employer doesn't, have the appetite for posting the No Surprises Act notice on its publicly available website, I don't think there's going to be any enforcement action against an employer for that, for that decision. But the machine readable file stuff has to be out there.
Right, I think that same individual's following up again and basically saying we would tell employees that these are available and provide the carrier link.
Again, like the notice is fine. The plan participants don't need to be told anything about the machine readable files. It's not a disclosure intended for the plan participant.
Okay, so we're getting close to 1 o'clock. It's 12:56. If there are any other questions, there are, I think, here we go. Machine readable files are due to be publicly posted by July 1, 2022.
Yes. So originally they were supposed to be posted by the first plan year beginning in 2022. End of last summer, the regulators pushed that date out to no earlier than July. So if you have a plan year that begins before July 1st, you don't have to post these your plan's files do not have to be posted until July 1st. If you have a July 1st plan year, the posting is July 1st. If you have an August 1st plan year, posting is August 1st. Okay, so that's the new effective date for posting of these files.
Excellent. Well, we are at 12:57, so I want to wrap up if we have no more questions, although if there are questions, you can send them to me at RIBGH and I will forward them on to Trish. But I would like to thank you very much, Trish, for spending the time that you have today. I've looked at this piece of legislation a number of times. I'm probably not the most sophisticated legislative reader, but it seems to me like there's an awful lot here and that we're going to be hearing about the CAA 2021 for a long time. So we will have your presentation posted as well as this video posted on our website. If, as I said a moment ago, there are any questions or concerns, send me a note and I will pass them on to Trish. And I'm sure that she will be able to give you a satisfactory answer. Thank you for those of you in the audience attending today. And we'll close by saying thank you once again for your support. Trish, thank you.
Okay, sure. Take care now. Bye-bye.
Bye-bye.